Good afternoon, everyone. Welcome back to the Insolvency Law Working Paper Series, Day 2, Part 2. We are now going to discuss the second working paper as a part of JGILS second edition. This particular paper is on insolvency proceedings and access to legal remedy, its constitutional perspectives, and our authors are Tala Abdul Rahman and Zafir Ahmed, both advocates on record with the Supreme Court of India. Our responders for this particular paper are Vipul Ganda, who's also an independent counsel, has a robust practice with the Company Law Tribunal, and Devanshu Mukherjee, who's one of the co-founders of the Center for Legal Policy, and we're very grateful that he's also a part of the board of editors of the Insolvency Law Working Paper Series. For the purposes of this particular panel, we're actually quite excited because thematically, we've typically gotten very commercially focused papers, and this is the first time we're talking about an intersectionality between law and constitutional principles. And with that, I would like to not take more time and invite Tala to effectively introduce the paper and get the session started.
Thank you. Thank you, Ishana. Hi to the responders, Devanshu and Vipul. The paper is insolvency proceedings and access to legal remedy. And we are going to be talking about some constitutional issues that we have seen coming up in the legal proceedings, especially in relation to accessing the forum. And that I thought required some bit of discussion from the people who are active practitioners and people who are behind the policy. And that's the reason why we decided to focus on the constitutional issues that arise in relation to the access. Now, this we'll be looking at the next slide. We'll be looking at two questions in our paper, and these are the questions that I have tried to that we both have tried to deal with. One is the classification of creditors and restriction on liquidation as a remedy. Who can be a creditor? What is the nature of remedy that is contemplated under the law? Who should the litigation be, or who should the proceedings be allowed against? Keeping in mind the broad objective of the law, this is one part of the question. And the second, something that we saw in COVID, was sort of putting a restriction on approaching NCLT qua a certain class of defaulters and for a certain period. So these are the two broad questions, focusing essentially on access to insolvency proceedings that we will be looking at, or that we've examined in the paper. Now, the framework that we've used to analyze this is essentially the framework of rule of law that, can you just shift it this side? I can't see. The framework that we've used is the framework of rule of law, which ensures that everybody is treated equally and fairly under the law. The idea being that the law should be the same for everyone and should at least provide for same kind of remedies for everyone, irrespective of their own financial understanding. So in a legal system, when we say that it should be the same for everyone, it is this understanding of everyone that we are looking at in our paper. We are examining whether different kind of remedies have been provided to different class of persons, and whether it really serves the purpose for which the forum or the remedies had been created. Now, as per the United Nations, which is focused a lot on improving the rule of law in various countries, they see the existence of rule of law as great benefit to businesses and other stakeholders, and this is because they see the existence of a robust mechanism as a factor on which businesses can then rely upon to make investment, generate employment, return a greater offer greater return of investments to businesses and to individuals who spend their time and effort in building the enterprise and contribute to the economy. But the exact content of rule of law is something that the scholars have not been able to agree upon. Whether it is something that that comprises only of the existence of a tribunal as a remedy, whether the forums have to be created, whether the right has to be created, to what extent should the right be created. You need to have an efficient and effective public institution. What is the meaning of public institution? What are the set of laws that you have to have? What are the kind of laws? So there is no consensus, because while there has been a great effort to judge which nation is more compliant or less compliant, or to what extent a nation has been compliant with the requirements of rule of law, there's been no consensus, at least scholarly, on what factors and how should it be measured, because the content is very subjective. But at least for our purposes, we've identified three principles that we're going to be focusing on. One is that the laws should be clearly written. It should be easily accessible. That creates certainty and enforceability of those legal rights that are provided by those set of laws. So within the first principle, there are four sub-principles. One, clear writing. Second, accessibility. Third, certainty that this is how the law is going to be interpreted, and so that people can then organize their affairs accordingly. And fourth, that there will be enforceability of that legal right. Now, the second broad principle is the existence of an independent, accessible, and impartial judiciary that can provide timely and predictable resolution of disputes. And the third is the effective and efficient public institutions. That is to say that the bodies that are going to make the law are effective and efficient, and the enforcement is guaranteed. These are the three aspects that we are going to be looking at or talking about at some length, and we invite the responders to help us arrive at hopefully a definitive way forward on this. In this broad framework of rule of law, the principle that we've tried to embark is that no right should get defeated. That is to say, a right of a rich person to access a remedy, or right of a poor person or a middle class person or a certain special class of persons should not be defeated by defining the law in a particular way, by defining access to remedies in a particular way, or by tailoring remedies to only a certain class of people. So, and this is very important, because if you have a law tailored in a particular way, it should allow others to at least be able to invoke other set of laws to get the same or similar kind of relief, if not that relief from a particular forum. And this ensures that people at least have a right to go under not a common law, but a law that offers a similar or a comparable relief. Now, in the context of bankruptcy, initially it arose from the phrase banca rota, where the money changers bench was broken. It was broken into two halves, indicating two things: that there is a distress, and third, that there may be inability to pay debt. So your person was disallowed from having a bench in a marketplace. And that's really the origin. And then with the development of limited liability, the personal nature of the insolvency that attached with a person was remedied by introduction of an artificial legal entity, which would then have a limited liability. But to my mind, the essential feature still remained, that the idea of doing this was to send two kinds of signals, that this person is in difficulty there, and therefore may be in need of a resolution of that difficulty or that distress. Now, that resolution could be in the nature of offering help, or disallowing that person from accessing market or lending mechanism or business other business related services, or it could be also an indicator to other parties to not to incur any further liability vis-a-vis that person. And this is the part that I want to emphasize a little bit. Next, because depending on, I mean, looking at our current regime of insolvency, depending on whether you are classified as an operational creditor or a financial creditor, certain special requirements are then triggered. So insolvency as a mechanism is available to whom is the question. There was a threshold limit provided under the previous law, which will never change with the changing market or situation or inflation. But the new legislation did provide a little bit of more flexibility, and that flexibility was recently used in COVID times, and that's something that Zafir would be explaining. And that sort of result, I mean, to my understanding, that resulted in exclusion of a certain group of people who could then not invoke or not use the remedy of insolvency proceedings, either to get their debt at the end of the resolution process, to whatever fraction or value was left, or even otherwise signal other persons not to incur any further liability vis-a-vis the insolvent or the defaulting company. Now, the other bigger question that we wanted to look in our paper was what was the event of default? What could you say is the reason for a person to be allowed to access the insolvency mechanism? Could it be non-payment? Could it be non-payment for a certain period of time? And this has led to the defining of the existence of a dispute in the current scenario, where, you know, if there's a dispute between the parties, then you're practically disbarred from accessing the remedy under the resolution process. But that's also at the same time, I mean, I'm not getting into that, whether that's should be allowed, not should be allowed, what should be the existence of dispute. But I'm just indicating that these are all factors that help in defining of what is an event of default. And linked with this is the factor of who's allowed to approach the court. Now, the reason why I flag it is because during COVID time, some of the people who approached me as for legal advice were people who, working with companies, were having difficulties in recovery of their salaries. And clearly, because of the notification that changed the threshold value, there was a difficulty in accessing the remedy under the insolvency laws. Now, and that is what triggered this paper that, you know, we are able to present today, is that should that person who's an employee earning, say, I mean, even if that person is earning, say, about 50,000 rupees a month, should be allowed to invoke the provisions of Insolvency Act, or should he be allowed to, or should he be compelled to approach any other forum for recovery of his debt? Now, I understand that provisions under the insolvency law are not, and I mean, and even in the previous law, they were not a mechanism for recovery. But eventually, at the end of the process, there is a hope that you will get at least some amount. But at the same time, what cannot be lost is that insolvency proceedings serve a dual purpose, which is they also signal to the others that there is a financial difficulty that the company is facing, and therefore do not incur any further liabilities. And this is why the importance for inclusion or exclusion of a certain group of people within the legislation becomes important. So, constitutionally speaking, there are two principles of classification that you can identify a certain group of people depending on what is the purpose of the legislation. Why should the legislation allow a certain group of people, and on that basis you can either decide to include or exclude a certain group of people. Now, there are two possibilities. One, either you define that either you have a definition clause that is under inclusive, that it doesn't serve the purpose, or over inclusive, that it includes way more people than it should have, and in that sense ends up destroying the very purpose for which the legislation has been made. Now, linked with this notion of who's going to form part of the group of people who are going to benefit from the legislation is the cutoff date on which the persons should have a definitive criteria to be able to enter those identified groups. So it's not only your individual markers, but the date on which you have those markers. So the legislative policy must be framed in that way. There is another, and one of the guiding factors this court have been using is the proportionality test, which where the court have reiterated that definition, or whether there is under inclusiveness or over inclusiveness in a definition will have to be looked at from the purpose of the legislation. Yeah, I'll just skip this. Yeah.
So I'll be taking over from here, and I will be talking about the employees as a class, employees as a creditor, which is basically what triggered this entire paper to begin with. Now, just coming straight to the point, so what really triggered is these post-COVID changes to the IBC, which is essentially twofold. One is Section 10A, which, if we read the objectives were twofold, which is as stated, that a lot of companies, because of COVID lockdown, a lot of companies were undergoing financial and economic distress. And second, even if we are to invoke insolvency process in respect of these companies, there was an apprehension that there may not be sufficient number of resolution applicants. That was one. And the second change that came about during COVID or after COVID was the increasing the threshold to 1 crore. Prior to 24th March 2020, the threshold for invoking insolvency was rupees 1 lakh. Now, the premise of this paper is that both these changes take a myopic view, because in a sense that they have only considered while bringing about the amendment, only the corporate debtor, that is the company's interest, has been considered. Whereas in an insolvency being a proceeding in REM, there are other stakeholders, which are employees, which are lenders and MSMEs, or service providers and goods providers, and who are effectively prejudiced by these amendments, specifically the operational creditors. Now, as per the IBBI reports, the annual insolvency reports, as of March 2020, there were close to 14,000 insolvency applications which were resolved. That is prior to them being admitted. They were filed and they were admitted. However, we do not have a breakdown as to how many of these were Section 7 applications, which is a financial creditor application, and how many of them were Section 9 application, which is an operational creditor application. And of around 3,900 applications were admitted, and of these admitted, after the admission, 715 were resolved. These were either resolved under Section 12A or on an appeal, or prior to constitution of the COC. Now, what is interesting is that out of these 715 applications which are subsequently resolved after admission, 518 of them, that is roughly about 76% of these applications, were actually filed by operational creditors. And these are all operational creditors who had a threshold limit of 1 lakh. So it's not a definitive conclusion, but it's a sort of conclusion that we are kind of forced to make, that by and large, the IBC is resorted to by operational creditors as a means of recovery for two reasons. One, it's expedited, and the fee and time involved is substantially lower, and as opposed to, say, a civil suit where a decree holder would still have to fight it after going through the entire process of the suit would still have to file an enforcement application to kind of give effect to the decree. Which brings us to the next point, which is employee as a creditor. Now, operational debt is defined as a debt in respect of goods or services and includes employment. Now, as per tertiary reports, secondary and tertiary reports, the median or the average pay in India is between 32,000 to 45,000. Now, when I say the median or average pay, it includes everyone, right? Right from the right from the top bosses to the workmen and laborers. Now, workmen and laborers, fortunately, there is a carve out, not specifically a carve out, but by a ruling of the Supreme Court in JK Jute Mill Mazdoor Morcha versus JGILS Jute Company, where they have said that a trade union can file on behalf of workmen, because trade union comes within the a registered trade union comes within the meaning of a person as envisaged under the IBC. And because they represent the collective interest of workmen and laborers, they can file. So suppose there is a large company and there are multiple laborers and workmen who have not been paid, then a trade union can aggregate all their claims and meet the threshold. However, this is where the aspect of over-inclusiveness and under-inclusiveness that Tala was highlighting comes into play. However, there is no such remedy available to an employee who is not a workman or a laborer. So a manager who probably earns about, say, 1 lakh a month, and who's put in his notice, and which has generally been our experience when prior to the amendment, that during the notice periods, most of the employees are not given their salary and they just let go and they just cut their losses and move out after 3 months or cut short their notice period. Prior to the amendment, one of the ways was filing an insolvency. Of course, we are cognizant of the fact that the courts and tribunals have repeatedly held that you should not resort to the IBC as a recovery mechanism, but it was in a way an effective remedy available to such employees. Which, but because of the amendment, there is no longer, this remedy is no longer available. So we started exploring the idea whether there is a possibility, because this classification of all employees as operational creditors and probably suffers from an over-inclusiveness in as much as their rights get seriously prejudiced. So we started exploring whether there can be a differential threshold that can be prescribed. Interestingly, prior to COVID, in February 2020, when the Insolvency Law Committee report published its third report, it had recommended increasing the threshold. But while increasing the threshold, it was cognizant of the fact that operational creditors, at that point, it was about 58%. About 58% of all applications were filed by operational creditors, which included, by and large, MSMEs and employees. These were the majority of the operational creditors who were filing Section 9 applications. So in its recommendation, even though the committee had recommended increasing the threshold to 50 lakhs, along with the recommendation, it noted few things, that operational creditors there could be a cascading effect in as much as operational creditors themselves, in the entire insolvency process, the operational creditors probably do not get much at the end of the day. So, and they're also cognizant and aware of the fact that Section 9 insolvency IBC is resorted to by operational creditors to recover their debts or dues, and often settle at whatever haircut. And because it was an effective means of debt enforcement. So because they have a bargaining power to settle, arrive at an out-of-court settlement. So keeping all this in view, the Insolvency Law Committee had also recommended that while increasing the threshold to 50 lakhs, for operational creditors could have a lower threshold, which is of 5 lakhs. This is as of 2020, prior to COVID and lockdown. But when the lockdown happened, it was just straight away increased to 1 crore, and the amendment was brought in suspending filing of insolvency applications. So this is the broad premise of the discussion that we would like to have on whether or not on what is the intent and purpose of insolvency, whether it is only a corporate debtor or whether it is also supposed to protect or take into account the interests of other stakeholders, and what are the effects that such stakeholders have to bear on account of an initiation of insolvency, and whether or not there can be resorting to IBC as a means of recovery. Thank you, and sorry for exceeding the time.
Thank you. Thank
So
you.
much, Tala and Zafir. I'll now hand over the mic to Vipul to respond.
Thank you. Thank you, Shana. Thank you for having me here. And thank you, Tala and Zafir, for the enlightening us on the aspects, and also taking us to basically apply our mind to various aspects of this amendment. So largely, as I understand, your paper intends to deal with the aspects in relation to the amendment, or I wouldn't call it an amendment. I would call it the amendment of the threshold rather than the amendment of the law per se. And that amendment having an impact on the operational creditors having a lower amount of debt than 1 crore, and specifically the employees. Now, the first aspect of your presentation and the paper, which is the rule of law and the accessibility, clarity, and enforcement of the law, I really have no qualms with the entire proposition. And obviously, as a country, we are working on all of these aspects, including the enforcement part, in relation to all classes of litigants. Now, coming to the amendment or the increase in the threshold. See, this threshold was increased by way of a delegated legislation. It was not a quintessential amendment where through an act of parliament, because the section 4 itself provides for increase in the threshold subject to a ceiling of 1 crore by a notification by the government. So therefore, it was not really a quintessential amendment, and it was by way of a delegated legislation. So the other aspect and the context in which this the threshold was revised was largely, yes, COVID was a trigger for it, but I think the intent was as sort of demonstrated in or enunciated in the law committee's report. The intent was that a person with a higher stake must come before the NCLT or the adjudicating authority to seek resolution of the corporate debtor. This was again in the context of two things: the operational creditors and the financial creditors. Now, inherently, financial creditors, when they seek a resolution of a corporate debtor, their intent is obviously the trigger point for them to come here is a default on the right to payment. So they obviously have to have a right to payment, and there is a default that would be the trigger. But the intent is perhaps to make its debt healthier, which can be serviced in the future in a much better way than it is being serviced as of right now. The operational creditors' intent would largely be, apart from, I mean, we all know that operational creditors have been practically taking the biggest haircuts in any resolution. So the operational creditors' intent for coming to adjudicating authority for seeking a resolution of a CD would largely be, I think, the future business opportunities that it may have once the resolution were to succeed. So in that context, and also the number of cases that were pending at that time and increasing by various stakeholders to NCLT, it was perhaps thought fit that the threshold may be increased. And it was always, when the legislation was enacted, it was always, I think, the intent that the threshold would be increased to 1 crore, because the provisor to section 4 anyway provides that the threshold can be increased to 1 crore. Now, I mean, and apart from these entire aspects, I think the other aspects were that anyway, the CIRP, the Corporate Insolvency Resolution Process, is not really a recovery proceeding as held by Innoventive or Swiss Ribbons and various other judicial precedents, and that these are non-adversarial proceedings. So therefore, for I mean, creating a situation where this is being used as a tool to recover was, I think, the intent was to curb that. Now, the other aspect that brings me brings a thought to my mind is the applicability of that delegated legislation, whether it was to apply prospectively or retrospectively. And when that analysis was to be done, whether the retrospective applicability or the prospective applicability was to take into account a relevant date and what that relevant date would be. That relevant date could be anything from the date of default or the date of demand or the date of filing or the date of admission. I mean, these are things that perhaps were required to be examined and have been examined in various judicial precedents. And I mean, the law has not evolved as much as perhaps one would have liked. But yes, as it stands today, it is the date of filing which is taken as the reckoning date rather than anything else. But I think those judgments also sort of did not take into account that CIRP is not a recovery proceeding, and it is not a non-adversarial proceeding, and it's not an adversarial proceeding. And the biggest aspect that perhaps they did not take into account is that I mean, it is the right to admission that entitles you to admission, not the date of filing, because on the date of filing, really no right accrues. As on that date, the learned adjudicating authority is still required to examine whether the default has occurred or not. And that, to my mind, should not have been the relevant date, and the relevant date should be the day on which the aspect is being adjudicated, because that is the day on which it will be determined whether a default had occurred or not. Because as of right now, as a litigant, anyone can come and say, yes, a default occurred to my mind on that particular day, and based on that I filed. But the date on which the law is being interpreted and the facts are being determined to apply that law should be the relevant date to determine whether a right to admission accrues or not. And therefore, even in the case of, I mean, although my view is completely contrary to the judgments that are existing today, although even though the petitions were pending, but if they were below the threshold as envisaged in section 4, they should have been not entertained, because the law did not entitle the adjudicating authority to entertain those. If one was to have a look at section 4, 5, 6, read with 7 and 9, the law needs to be applied on that date as it exists on that date. Had it been a quintessential amendment, yes, in that scenario, the law would have been sort of amended, but it is not. It is a delegated legislation through which the threshold has been increased. So therefore, the date on which the matter was being adjudicated should have been the relevant date. But yes, that is something perhaps the Supreme Court will decide, because as of right now, the judgments that are there on this aspect are either by the NCL, various NCLTs, or the Honorable NCLAT. So yes, these are my large the thoughts largely on this and on this aspect. Now the the various judicial precedents that are there, I mean, in the context of employees. Now, as Zafir highlighted, that these are not recovery proceedings. Now, yes, as an employee, if one was to approach the NCLT, I mean, either an employee who has more than 1 crore of outstanding debt can approach, and a person lesser than that could not perhaps approach. Yes, that is something we'll have to sort of accept as it exists today, because I mean, if a person who has lesser debt than 1 crore would, to my mind, would not be a large enough stakeholder to determine how the resolution process must proceed and the manner in which and the direction it should go. It is I mean, I'm saying this from the law committee's report, that these are aspects that must be gone into by a sophisticated creditor, such as a bank or a financial institution, or an operational creditor having a stake above 1 crore, or if he intends to be on the COC, then more than 10 crores, to drive the resolution process. Because at the end of the day, they are the biggest stakeholders running the company, or I mean, where the corporate debtor is dependent on these kind of people to have for their business, the operational creditors or the suppliers or the bankers. Yes, employees are a bigger aspect also, who sort of manage the company and perhaps operate the company. And for that, there is adequate protection in Section 53 of the IBC, where they are workmen. As a person who is a workman is treated at par with a secured creditor on a pari passu basis. So therefore, in the event a resolution was to take place or liquidation was to take place, they would be right up there. After the CIRP cost, it is the workmen who will be taken care of. So as far as that kind of protection is concerned, I think the workmen are adequately protected. So, I mean, yes, from an optics perspective, it does seem that a complete class of creditors has been excluded by the increase in threshold, whereas the other class they remain unimpacted. But yes, I mean, that is also one of the aspects that was considered by the law committee's report, that workmen and the employees are adequately protected as far as the waterfall mechanism is concerned, because they are right there. I mean, workmen is number 2, and after CIRP costs, and employees are number 3. Employees other than workmen are number 3. So yeah, I mean, these are perhaps some things that can be thought about, and I leave it at that, and over to Devanshu for his thoughts.
Thank you, Vipul. Ishana, can I go ahead?
Yeah, please.
Thank you, Tala and Zafir, for the excellent paper. Not a lot of people write about the interrelationship between IBC and constitutional law, so it was heartening to see the paper. I think most of your points are absolutely valid. I just want to talk about the legislative background a bit to possibly help us understand why is it that we have the provisions drafted in the manner that we have. Now, as you know, before IBC, we had the BIFR regime under the Sikh Industrial Companies Act and the winding up regime under the Companies Act. Now, what was the treatment of OCs under both those regimes? So as far as BIFR is concerned, OCs had no power to initiate. It was only the company which could initiate, and that also after erosion of net worth, essentially after the company had gone beyond redemption. But OCs were relevant for the purpose of resolution. And unfortunately, in most cases, OCs insisted on full payment of their dues, and that led to all kinds of problems. So their participation in the BIFR system led to lots of problems. There were no outcomes. So the committee thought that yes, they need to be protected, but at the same time, we need to find a way of keeping them out from the decision-making process, because that, at least under the BIFR regime, led to all sorts of problems. Obviously we can argue from both sides, but by and large, the committee decided that, okay, let's exclude them from that process. But on the other hand, the committee also recognized that under the winding up regime, the OCs had this right to file a petition for winding up if there was a default, right? And if we are taking away that right, so that right must necessarily be replicated in some shape or form in the IBC. And therefore, if you look at the admission process, OCs have that direct right. The moment there is a default, obviously the process is a little different for OCs in comparison to FCs, where it's relatively easier. For OCs, we thought that, the debtor should have the ability to dispute it if required, and therefore the process is slightly different. But at the same time, it's way more effective in comparison to winding up. Because in winding up, as folks who have litigated would know, it was extremely difficult to get a case admitted. On theory, you had a remedy. In theory, you had a remedy, but the courts would typically not allow a case to be admitted just on the basis of default. They would get into the balance sheet insolvency. They will get into the commercial insolvency test. Although the statute specifically provided for a simple default test for admission, right? So there was a remedy under the statute, but it was of no use. So what we did under IBC was quite radical, and one might say that it has led to lots of problems where now it's become far more easy. And as you were showing the data right up to 2020, where OCs were filing way more cases. So so one might say that there is some abuse also that might be happening. But by and large, as far as the admission process is concerned, the intent of the government was to make sure that OCs are adequately protected, because we are taking up a winding up as a remedy. Okay. Now, and we've already discussed why they've been excluded from the process as such inside once the company gets into CIRP. And that piece has been litigated. Supreme Court has upheld the constitutional validity of that distinction between FCs and OCs. I'm not getting into that. Now, let's come to this notification. Okay, so as you said, the ILC, the Insolvency Law Committee, which is actually a government committee chaired by the secretary of the MCA. It's essentially, so in a certain sense, although it's a committee, it's a government report and reflects the government's position in a certain sense, had taken a categoric view that yes, we need to increase the limit up to a certain number, but at the same time, OCs need to be treated differently, and there should be a lower threshold for entry for OCs. And that piece is reflected in the report. But unfortunately, because we had COVID and we had the pandemic, and the report had just come out right before the lockdown, it was very strange timing in that sense. So here we have a report which is recommending something very different, and the government then eventually issued a notification which was not in line with what the report had recommended. But let's understand what was happening at that time. I think government's priority at that time was to make sure that we somehow mitigate the damage that this, the economic damage that this pandemic might possibly cause for the economy. And therefore, they thought in their minds at that point that let's limit insolvency as a remedy to the extent possible, because a lot of people will default, as during the pandemic. And if all of them start filing, then we just don't have the infrastructure to kind of cope with that. And they came out with an amendment for not allowing filings for defaults that have happened during the period. But even beyond that, they had to ensure that even for old defaults, if there is a possibility, let's just try to increase the amount and fix it to 1 crore. But in my assessment, that notification has kind of served its purpose. And if somewhere were to kind of question the government today and ask them to re-examine it in light of the ILC recommendations, I think they should be prepared to do it, because the purpose of that notification was very different. I think that purpose has been served in, and I don't know whether it's been argued in any case so far, because I don't practice, but it's very clear to me that the original intent of the government was not to take away the remedy in the way it has been now. And I'll just give you an example as to why a lower threshold for OCs is extremely important. So I fully agree with you on that. Now, when the law was being drafted, we also had this Kingfisher bankruptcy playing out. Now, we all know that Kingfisher had been defaulting on its financial loans for a very long period of time, right? And it had been trying to restructure year on year. There have been lots of CDR packages that it had gone into and then come out, etc. But it's only after it started defaulting on its payments to employees that it became an issue, that people started raising a stink and there was some political momentum around it. Right. So until then, it was like business as usual. It's a huge business. There is an economic problem. Let's try to explore something in CDR. But it's only when the aircraft engineer, they came up and said that, boss, we are not certifying these aircraft anymore if you don't pay us. The airline was grounded. And then people started talking about it. So it's and those aircraft engineers, I'm sure they were not recognized under any trade union or whatever. So therefore, it's extremely important for us to recognize that for early detection of stress, it's important that even folks who have lower amounts of outstanding debts should be allowed to initiate the process. And that was the thinking from day one. And that's why the threshold was so low in the beginning. And then in the ILC report, the idea was to move it to 5 lakhs for OCs. But because of the pandemic, that wasn't done. And my submission is that we now need to go back to that ILC report to lower the threshold for employees. Now, again, coming back to Kingfisher. Now, the irony is that had the employees of Kingfisher not raised up a stink in the manner that they had, I don't think IBC would have been enacted in the shape and form that we see it today. Because IBC provides for displacement of management, which is a huge thing in the Indian context, right? And originally, in all honesty, I would say, in my personal opinion, when I was working as part of the team, I thought this piece will definitely get diluted in the parliament, given the political economy. But given the Kingfisher controversy was playing out in the background at that point, nobody opposed it because everybody realized that this is a real issue. If someone is not paying their debts consistently, and it became a big issue, a political issue, because the employees brought it out, right? And so that kind of because banks had been trying to resolve for the last 3-4 years before it became a huge issue. It's only after employees started talking about it did it become a huge issue. And I think, therefore, it's all the more important that that right of employees should be protected. One might say that, employees should be able to file in separate forum, enforce their contracts in courts, labor courts, etc. But given the fact that bankruptcy is such a fantastic, effective remedy, where if someone has a genuine debt and if the employees and the employer is genuine, unnecessarily not paying him, then we should be able to take him to bankruptcy court. And if you have the money, just pay him and get out. But if you don't have the money, then you have to be subject to bankruptcy proceedings. That's the law. So so that's my position. So therefore, broadly, I agree with you on on your analysis as to why the bifurcation of this notification could have been done in a more effective manner, but it wasn't. But I think the government, when it issued the notification, was fully justified, and I completely support that piece, because at that time when they first came up with the notification, it was justified, because there were valid reasons for having a kind of a general threshold that applied to everyone, because we're looking at a different problem altogether. But coming back to the original intent of the law, I think it's very important that we have a lower threshold for operational creditors. In any case, we know that operational creditors are unlikely to get anything substantial in the final piece, if because they come down low, they come down lower in the order of priorities. So, but still, that effective remedy of initiation is very important. Otherwise, you will again have cases like Kingfisher in the future, where maybe financial creditors will not initiate the proceedings in time, and the company will will start going deeper into bankruptcy, and it will reach bankruptcy only when it's become the problem has become intractable. So therefore, for early detection of stress, it's all the more important that we have a low threshold, especially for employees. Yeah, so I broadly only wanted to talk about that. Happy to answer any questions.
Thanks so much, Devanshu. You set the stage up for a debate instead. So we're going to just be here all day, as a policy person must do. But what I would like to allow the authors to take 5 minutes, because I'm mindful of time, maybe 5 to 7 minutes to respond to each Vipul and Devanshu, and then we can open up to take 1 or 2 questions for the panel in general.
Go ahead.
Thank you, panelists, for your views. So on the aspect of the notification, so the reason why we kind of focus, and we have formed the view that it is probably focused only on the company, was because there were other measures as well which the government was implementing. One, of course, Section 10A, which in any way had suspended invocation of IBC. And the other was being the moratorium, which the RBI had anyway granted in terms of repayment. So which could not have, at that point, which could not have triggered a default. That was one of the reasons why we felt that, because at the end of the day, I mean, this is something that I forgot to highlight while I was presenting, because about 65% of insolvency applications where the debt was below, this is again as of 2020, where the debt was below 1 crore was filed by operational creditors, and 80% of the debts above 1 crore was filed by financial creditors. So clearly the operational creditors were using this as a means to kind of recover their dues. And this is again coming from a practical experience that I faced, is I actually had a client of mine who was routinely, I mean, we used to resort to insolvency to kind of recover his overdue payables. And it so happened that once insolvency had come into effect, he could not do it. And but he was severely impacted by it, because when I had a discussion with him, one of the things that he highlighted is that, like, my debt, the recoveries from each company may not be many, but he's a service provider to multiple companies, and he's an MSME, and he's a service provider to multiple companies. And as it happens, a lot of the big companies that have gone into insolvency have all been his debtors, and he has his claim and everything. And he at the end, in cases where insolvency has been resolved, he's gotten a nominal payment of 1 rupee in those matters. So, which is why it's a kind of a personal anguish that he has, that if he could have been the first one in the door, then his debt could have been settled. So that is one of the aspects. And of course, again, when I make this one, we are very, very well cognizant and aware of the fact that it is not to be resorted to as a settlement tool. But if that is the case, then my kind of counter argument to that would be that if that is the case, then once it is filed, then you should not allow for a settlement at a haircut value at all, right? Because that is what is happening, because that's what's happening primarily with operational creditors. You either settle their dues in full or don't let them settle at a haircut. But then it of course will have other repercussions on converting the NCLT into sort of a recovery or a negotiation forum. And the counter view to that is, in instances, again, this coming from practice, instances where there are asset-rich companies which have a financial debt, but due to liquidity crunch, they're not, and probably all, and this is something that I personally face as well, where a corporate debtor has most of its property assets mortgaged with the bank, mortgaged or hypothecated with the bank, but they are facing a liquidity crunch, and they make repeated requests to the bank saying that, allow us to hive off some property and the entire debt will be settled. But the banks do not agree for that, and they invoke insolvency. So for a recovery of an amount, X amount, they kind of put an asset worth, say, 5x. They have some of the financial institutions are happy to drag a corporate debtor with almost 10x or 5x of the debt in its asset bank to insolvency. So it's under these circumstances that we kind of formulated the paper and came up with this proposition as to why recovery for operational debt. And like Mr. Devanshu rightly pointed out that, I mean, I'm not saying rightly pointed out, I pertinently pointed out, if I may say, that the context of what you said about the Kingfisher, that it is an early trigger, early signs of distress and the earliest signs of distress is always the employees who are not being paid, and which is the reason why we feel that the employees being left out is kind of counterproductive and counterintuitive to the intent of the IBC. I'll let Tala address.
Thank you, Zafir. Thank you, Devanshu and Vipul, for your wonderful comments. On Vipul's section 53 argument, you see, my difficulty with that, and from a constitutional access to court or remedies point of view, is that in a way, because of the threshold restrictions, it says essentially that, all right, we won't allow you to invoke the remedy, but in case there is something left, we will give you.
Right.
So don't worry, the law will protect you if something happens, but we won't let you access it. Even though you may be the first person, as Devanshu pointed out, you may be the first person within the company to understand that something is going wrong, that, you know, the company is not able to serve financial creditors or not able to serve employees. And probably, you know, the long-standing employees are the first one who are told, like, you know, you've been working with the company for a longer time, we won't be able to give you money immediately for 2 months. So, you know, let us pay the bank first, and then we'll pay you after 3 months, or some sort of thing. So the understanding of what is going wrong in the company is first with them. Now, this is of some significance for 2 reasons. One, because of the nature of remedy, which is for the public. And 2, it's an indicator to other, maybe smaller players, to not deal with the company, or at least deal with the company at their own risk. So in the way, it alerts the other people dealing with the company that there's something that's going wrong. And if it's a company that has money and has moral compunction to not pay the employee for whatever reason, not like the work, want to terminate him, want him to terminate without reason, has some malafide, other reasons, that could not be used as a defense. So, so there is, I have that problem with 53 because it doesn't gel with the access point of view. I think I fully take Devanshu's point about using Kingfisher as an example, and possibly, we could build that in some point in our paper and correlate how the events in our lives in the corporate world in India have shaped the law as we see today. Thank you.
Can I just respond? I'll just take 1 minute, I think, on the access point aspect. See, yes, I agree. As I said, I also mentioned that optically, yes, from an access point of view, a complete class of creditors has been, the right has been taken away. Yes, that is, but one must need to appreciate that the legislation of IBC is a beneficial legislation for the corporate debtor, where resolution of the corporate debtor is the aim. Therefore, the access perhaps is secondary there, because at the end of the day, it is the resolution of the corporate debtor which is the intent, and the legislation has been incorporated only for the benefit of the corporate debtor, and consequently, as a result, to make its debt healthier, who are the operational creditors, the employees, or the financial creditors. So therefore, I would say that yes, I agree that one must have an access as enshrined in Article 14, like everyone else. But if that right existed in the first place, because this right actually exists only for the benefit of the corporate debtor, it is only the trigger which is given in the hands of various financial creditors or operational creditors owed a debt of more than 1 crore. So maybe we can think about it from that perspective too. And I'll just leave it at that. And
can I just say one thing here? Like, I know that the Supreme Court has held that, the law is largely, tailored for resolution. But at the time when it was being drafted, the idea was that the law is actually, outcome neutral. once the company, the idea is that if there is a company which is under financial distress, we should find a way to bring it under the system as soon as possible. And once it's in, the committee of creditors will decide as to what needs to be done with it, resolve or liquidate. So the COC will decide. And therefore, I think the primary intent of the law is to protect the stakeholders. And the committee of creditors have been given that responsibility, that fiduciary duty to take care of the interest of all the stakeholders. So corporate debtor, of course, is the entity we are dealing with, but my sense is the law is largely about protecting all stakeholders. And therefore the access, and that access is also important. So we have to see the question of access in light of this overall objective of protecting all stakeholders. I agree with you that, just because you have the right to initiate does not mean that you will be protected ultimately in the resolution, because there is a waterfall. No matter who initiates, the distribution will be as per that waterfall. And in most cases, OCs will get nothing unless the COC thinks that, this OC actually adds value, so I'll give him something. But the fact of the matter is the law actually talks about protection of stakeholders in accordance with the waterfall that has been agreed upon. So the waterfall that the parliament has, legislated for us. So, broadly that, and therefore OCs, the most effective thing that they have is that given the fact that they can initiate it, if there is a, genuine, if there is no genuine problem, in most cases, the debtors paying the OCs to get out of the situation. But the other side is that if there is a problem with that debt, and it's actually a disputed debt, and OCs and the debtor is now getting arm twisted to pay the OC just because he now has this power. So, but that's a problem. So, but that's something that you as lawyers need to solve in courts. But the law and the policy, unfortunately, cannot provide a solution there.
Right.
Thank you.
Thanks so much for those thoughts. A lot to sort of moderate and correlate, but I'm just going to sort of put together a more generic question that comes out of this particular paper. So one observation, one question, and then one audience question. Just in terms of like the observation, I feel like at this point where we are vis-a-vis implementation of the insolvency law as it is, I think it is about time we did a reassessment of liquidation priority and the resolution sort of that takes into consideration different sort of OC rights. I understand the protectionist approach that was taken when it came to operational creditors in general, when it came to resolution and under the BLRC. And I think it's extremely critical for us to sort of separate the employee creditor versus the operational creditor, especially when we talk about access to legal remedy, because as we see it, you don't really, as an employee, you are not really incentivized to initiate a bankruptcy of a company. And that is just the observation that I want to make, because there's a plethora of literature that has effectively argued both for and against employee being identified as a creditor to initiate bankruptcies for companies, right? Because the assessment or the commercial assessment is missing, and that is the international literature on this, very, very sort of simply put. The comment sort of question for the panel around, and I want to customize it to where each of you come from, the expertise that each of you bring to the table, is that when we speak about the issue of intelligible differentia, right, especially when you're talking about intelligible differentia amongst various classes of creditors, I was wondering why your paper didn't really look into various classes of financial creditors and various classes of operational creditors, because I think the jurisprudence has evolved to categorize them separately. And even the BLRC, when it was being drafted, did very categorically in the liquidation waterfall, which is to be adhered to under Section 30 also looked at unsecured financial creditors and secured financial creditors separately. And I feel like at this point, especially when you're talking about sort of equality and not really equal treatment, equality in terms of creditor rights, we have for a very long time not really just let the resolution plan cater to OCs and not really looked at the different categories of financial creditors that are brought into the table as a part of the resolution plan. It's really just left to either resetting the security interest, which is what you saw ICICI Bank do in Bhushan Steel. And that is something I was wondering if Tala from a and Zafir from a constitutional perspective, what your thoughts were. Vipul, I just wanted to get a sense of how frequently is it that you have seen secured creditors bring secured OCs or FCs bring proceedings to IBC, right? And whether then is the remedy just predominantly available for unsecured creditors, and by virtue of that, you have effectively allowed insolvency proceedings to balance out rights by having a law like SARFAC. And Debanshu, what was the thought process being between categorizing specifically unsecured financial creditors as a part of the liquidation waterfall and not providing them as part of Section 30? Because I do very briefly recollect that this was a very conscious choice that was made. So I just wanted to just go around the table and get your thoughts.
Before we go into, just to kind of add on to Ishana's question as well, even within secured creditors, you would find a lot of times that resolution plan itself makes distinction of secured creditors where someone is allowed to set off their dues are settled by discharging the secured asset in favor of the creditor, whereas in some aspects, some secured creditors as the security is brought into the pool of the corporate debtors' assets. So even within the secured creditors, secured financial creditors, you have the kind of subclassification. Sorry, thank you for the, yeah. Even within the secured financial creditors, you have this separate treatment being given, and of course, at the end of the day, it's the commercial wisdom of the COC which kind of prevails in such circumstances. So I just thought I'll kind of highlight that as well on the practical aspect of it before we open the floor for the discussion on this.
Right. So, yeah. So as far as secured operational creditors or secured financial creditors coming to the adjudicating authority for invoking or for initiating CIRP, I think recently there has been a trend where secured operational creditors have been coming very often. And the biggest example of that is Noida, because Noida is considered to be a secured operational creditor, whereby under its lease, it is to get the lease rentals, and it is not being sort of and the lessee is defaulting on that. So they've been coming very often recently. Earlier they were declared, initially when they had come, they were declared as a financial creditor. Then the law changed on that aspect. They were considered to be operational creditors, and now they are secured operational creditors. So that trend of secured operational creditors has recently sort of increased. The other aspect of categorization and whether within the secured creditors itself, see, again, largely it depends on the facts of each case and also the commercial wisdom of the secured financial creditor rather than the commercial wisdom of the COC here. Because if the release of a particular security would entail getting that secured creditor the entire amount in the waterfall, then perhaps at that time it is becomes wiser. It would be wise commercially to release the security in favor of the COC. On the other hand, sometimes it creates a situation where the benefit of the security is to be used by that particular secured creditor itself. So in that scenario, obviously the secured creditor would not release the security in favor of the COC or the rest of the creditors. So, I mean, these are very factual issues which would depend on the facts of each different case. So difficult to answer in general, but yes, I mean, it is actually the commercial wisdom of that particular secured creditor which would matter in that scenario.
Yeah. So, when the law was being drafted, there was overemphasis on secured credit in India. And the committee consciously took the view that as far as the CIRP process is concerned, let's not talk about security interest at all, because they also wanted to promote other forms of financing in India, right? And specifically, they had the bond market in view, and because a lot of bond market financing will be unsecured. And therefore, the CIRP piece was, at least in the beginning, completely silent. But we also knew that most financial creditors, given the market practices in India, will be secured. So they will, and because they have the power to decide how the company will be resolved, they will take care of their security interest as part of the resolution. But ultimately, in SR, it had to be settled, and then that clarification had to come that no, you have to protect security interests even in the rights of secured creditors even in CIRP. But the original intent was to keep it very neutral. Then, as far as 53 is concerned, there was this realization that there are ex ante rights, secured, unsecured, which need to be specifically recognized as far as 53 is concerned, because it's essentially a waterfall for liquidation, which now in a certain sense is also applicable to the resolution process. But as far as 53 is concerned, the idea was that there we will have to very clearly recognize that secured creditors stand on top of others. And therefore you have multiple kind of buckets under 53. And as far as unsecured financial creditors, having been placed above other unsecured creditors, the idea was again linked to the bond markets. The fact that there could be, we want to promote other forms of financing in India, and if this is just a small nudge that if at all the company goes in liquidation, you will have better protection in comparison to other unsecured creditors, and therefore they've been recognized as a separate category there, and they come slightly above other unsecured creditors. And even within unsecured creditors, you have multiple categories in 53. As you have workmen, you have employees, and then you have other unsecured. So 53 does recognize multiple categories. It's only CIRP where it's all kind of neutral. But 53, so the drafting of committee was aware of all these classifications, but they consciously didn't want to provide for anything in the CIRP piece, because they knew that the COC is deciding, and whatever it decides should hopefully be in the interest of all the stakeholders. And with, of course, protections for dissenting and operational creditors, where 53 again comes in, and where you have to respect those priorities. So broadly that. I hope I answered your question.
Right, Devanshu. I'm going to basically end the note because we are over time with a controversial question. Why have we not discussed government creditors and their rights as a part of this panel with access and their treatment in insolvency? And I think we can perhaps shorten the answer that it was to an extent a bailout structure where the government was therefore rejigged into the waterfall. And if there's a different answer, then obviously the Devanshu can provide that to us. But we're on this sort of controversial question.
No, so just to keep it short, and hopefully this will answer the question. See, who is the biggest financial creditor in India? It's essentially the government, right? Public sector banks. So the choice between government was to protect its banks or the revenue authority. And at that point, given the scale of the NPA problem, they took a very clear view that no, the secured creditors have to come on top in the waterfall, because we're essentially talking about our own money. It's the government's money after all, with public sector banks, which is stuck in NPAs. And therefore, the answer was very clear. Now, this, and of course, a lot of other financial creditors also benefit from it, but the biggest beneficiary is the government itself. And this piece gets missed out very often in this debate. And when the government authority is fighting against this waterfall mechanism and asking for more, they should recognize that they're fighting against another arm of the government. And the parliament, because this was discussed, parliament, because in the committee, where all these representations were made before the parliamentary committee, which was looking at this bill, and they also consciously decided to push government down because they recognize that this is public money at the end of the day, which needs to be recovered. This is not private money. And therefore, it's not that government is being pushed down. It's government is being protected as a result of what we have.
Right, I agree.
Yeah. Any other sort of answer?
No, we can provide only from the context of the premise, which is the right to remedy, and the answer to that is like most of the government, the statutory authorities have within their statute means of enforcing. For instance, under the Income Tax Act, they can go after the director if the companies don't pay the dues. Similarly, under the GST statutes, also there are similar provisions. So I think in that aspect, I don't think the statutory authorities really invoke IBC as a means of recovery, perhaps.
But let me tell you, I mean, as a council, I'd appeared for income tax department in a matter where, one of the post resolution, there was a demand from the income tax. The income tax department was not willing to let go. And, again and again, attention was being drawn to the resolution plan where they said, look, boss, you don't get anything. But they were just, very hard for the authorities to also let go of something that they have always, habituated to get. So that culture, the change of the mindset is yet to, come down to the authorities.
And also, I think the question in that context is also who will bell the cat, because they want a stamp of the court to say, yes, you are not entitled. Because at the end of the day, no one wants to take responsibility.
Yeah. True.
In fact, this has been a long-standing problem under all the pre-IBC regimes also. The income tax authorities always came during the insolvency proceedings to ask for their dues. So all the committees, if you look back, even Raghuram Rajan's committee in 2009 had said that, boss, why don't you do it when the company is solvent? Why do you wait for this stage? Because the recoveries date back to, pre-insolvency times. So why do you want to recover everything now? Now that a company is in insolvency, now it has to be as per whatever the waterfall is. And, even if you have to get something, get a, basic minimum and then get out, let the others have their due. Because your dues relate back to, a time which is even, beyond insolvency. But broadly, the point is that in IBC, if you've noticed, we also simultaneously made amendments to all these other statutes, Income Tax Act, Customs Act, Excise Act, specifically saying IBC prevails, please. This is sacrosanct, please don't touch. But obviously litigation can't be stopped because they have to, at the end of the day, they have to recover their dues, but they must realize that the law has actually overridden that right. So, but litigation can't be stopped, unfortunately.
On that very positive note, I think we can close out this extremely sort of debatable and filled with sort of questions for Tala and Zafir to elaborate on in their paper. Perhaps it can be split into 6 papers and update this particular working paper. This has been an excellent session, gentlemen. I think one of the biggest conversations that we have to effectively take forward when it comes to insolvency law is to effectively understand its customization to different stakeholders. I think in the overarching spirit of recovery, so as to speak, that seems to be forgotten as to why it is a comprehensive legislation to protect multitudinal stakeholders together. I do believe that when it was drafted, it was a beautiful piece of legislation. And now I struggle to read the judgments on it. So kudos to the litigators on it as well.
Successful largely because of the practitioners, because there have been other attempts to draft such laws in the past, but It's only now that it's being implemented properly. So I think practice.
Devanshu, let me assure you that practitioners don't like to buy several copies of the same Bare Act.
I wish we could get a royalty out of it. We don't.
So with that, we'll close out day 2, part 2. We have thank you so much for people listening over. About 100 of you have tuned in. So thank you. And we will close out this working paper series on Tuesday, which is the last sort of day with a paper on financial institutional insolvency. We have 1 hour, which is supported and represented by the Insolvency Law Academy. I want to re-thank all our collaborators, Vidhi, Insol India, Insolvency Law Academy, and Red Intelligence for making this possible. I want to very much thank AV Support that has spent Sunday streaming this for us. So thank you to JGILS, and thank you to all of you again, and have a good Sunday.
Thank you, you too.
Thank you all.
Thank you.
Thank you.